In an unprecedented judgment from the highest court in the land, the Prime Minister has been found to have acted unlawfully when he asked the Queen to suspend Parliament. Pause to unpack that. Prorogation never happened. Parliament has returned. The rule of law has been restored. This is constitutional and political dynamite. Whatever happens next, vote of no confidence, general election, second vote, caretaker PM, is anyone's guess. And the only certainty is yet more turmoil and confusion. But the one thing we can say for sure is this: the Supreme Court has unanimously ruled that Parliament is sovereign over the Crown and the government. Whatever your persuasion, left or right, leave or remain, this week has been a good one for our parliamentary democracy.
The truth is, the government's defence of their position was pathetic. Now, the question I ask is why? Why did they not make a decent case for themselves?
The general principle is,
yes.
Who is sovereign? What is the highest authority in the land?
Obviously the Supreme Court, currently. But what needs to come out of this, as and when, if and when, is we probably need a written constitution. Yeah. That is what I think we are moving towards.
Can we just remind everybody that what actually happened was that the leader of an executive government, on a mandate of 90,000 Tory members, on that authority, decided to suspend a parliament of 560 elected MPs during the most difficult and constitutionally complicated period of this country's modern history. Greg?
Well, I thought, when you looked at what happened, I just thought, your point, if this had gone the other way, what we basically
Sorry, explain what you mean.
Well, if the judges had found...
Okay. It was lawful.
It was lawful. Then that means any Prime Minister can prorogue Parliament any time they want.
That's what I was saying.
That has always been the case, Greg.
No.
It has always been the case.
No, but there's been convention has applied, whereby they've only done so for 4 or 5 days.
We have a constitution based on tradition and convention. Now, you're probably right, Nick, it's the time to start writing it down and say we can't do that anymore because it perhaps gives too much interpretation to the judges. But all they said was, the reasons you have given for this prorogation are not valid.
The reason the judges have had to stick their oar in is because parliamentary sovereignty has been eroded since the referendum result. And we've had to hear from one woman, Gina Miller, who has had to establish the principle that Parliament is sovereign not once but twice since the referendum result. First, that Parliament had to have a say on the deal. Secondly, that Parliament could not be prorogued. So let's hear from Gina Miller.
It doesn't really matter who is Prime Minister. The office of Prime Minister cannot decide to abuse their power and close down Parliament, our elected representatives, if that Parliament is disagreeing with them. If we had lost our case, if I'd lost the case, then the precedent would have stood that a Prime Minister could just close down Parliament for 5 weeks. And that is not right. Our parliamentarians are there to represent us. It really is important to understand that this case is much, much bigger than Brexit. It is about a Prime Minister abusing his power and actually giving the Queen illegal advice.
Gina Miller, not an anti-Brexit activist, not a pro-Remain campaigner, simply standing up for the rule of law and due process.